Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Most recent development in the federal lawsuit against the Order in Council, that's the order that bans a number of firearms, including the AR-15, is that the federal government has decided to invoke Section 39 of the Canada Evidence Act to block disclosure of certain documents that they were ordered to produce. Now, they were ordered to produce these for the justice's eyes only. The justice was going to get these documents and was going to look over them and determine which, if any, were then to be disclosed to the parties. However, this was a big win when they ordered that for gun owners as well as just for transparency, right? The government is making decisions. We should have some insight into how they're making those decisions and why. However, that's not going to happen. So this is a press release from the CCFR. I'll link it in the description below. I'm not going to read it to you. You can check it out yourselves, but it provides some information about essentially that they received this notice and that basically means that the government considers this to be too secret to produce. So let's have a look at the notice they received as well as at Section 39 and some of the relevant case law, because people have wanted a bit more explanation for this, and I figure, hey, I can do that. Also, I've gotten I can't even count how many people have said, do a video on this. It might be my entire subscriber total. I could really believe it was 33,000 people. So I better do this video just so that I stop getting those notifications. Let's start by looking at the letter. So the letter is directed to the attention of Associate Chief Justice Gagné with respect to the proceeding, and it states, this letter is in reference to the court's order of May 27, 2021, in which the court ordered, the respondent will file under seal within 30 days of these reasons the documents described in the letter from the General Counsel, Office of the Counsel of the Clerk of the Privy Council of Canada, dated December 4th, 2020. The respondent is the government, and filing under seal means that they're filed, but you can't go and order a copy of them. They're for the justice's eyes only. They're restricted. So that was the original order. Now, in response to that, they say, in response to this order, and consistent with the written representations made by the Attorney General of Canada, the Clerk of the Privy Council has now exercised her jurisdiction and invoked Section 39 of the Canada Evidence Act to certify the information that is subject to the order as constituting a confidence to the Queen's Privy Council for Canada. In doing so, the clerk has exercised her statutory role to weigh the public interest in disclosure against the public interest in non-disclosure. A copy of the certificate is attached for filing with the court. As a result of the certification by the clerk, pursuant to Section 39, disclosure of the information shall be refused without examination or hearing of the information by the court. Consequently, the attached Section 39 certificate is an absolute bar to filing with the court under seal the information encompassed by the order. So what this means is, listen, we're aware of your order, and we've exercised Section 39, which says that we don't have to file this information, and we're not going to. So you're not getting it. Here's why, and please see attached. So yeah, that's where we sit now. Let's have a look at what all is in there. So first is an affidavit, and you can get this affidavit off the CCFR page. Otherwise, I probably would have skipped over it. There's a person's name mentioned in it. Please don't try to track this person down. They haven't done anything. They don't have any decision-making power here. They're really just somebody who happened to be handy to sign this affidavit. So I, person residing in the city of Gatineau in the province of Quebec, declare and say as follows. I'm the interim chief of staff in the office of the clerk of the Privy Council and secretary to the cabinet. And you can see that they've had to correct that and initial it. There's nothing to worry about there. I know Janice Charette to be the interim clerk of the Privy Council and secretary to the cabinet. On the 14th day of June, 2021, I witnessed Janice Charette sign the certificate attached hereto as Exhibit A, dated the 14th day of June, 2021, etc., etc., etc. So what this affidavit is there's another document attached to that, and this affidavit explains what that document is. This is basically just kind of a helper affidavit. It doesn't do a whole lot other than to introduce the next document that we're going to look at, which is the certificate. This is I, the undersigned Janice Charette, residing in the city of Ottawa in the province of Ontario, do certify and say, I am the interim clerk of the Privy Council and secretary of the cabinet. I've examined the information described in the schedule attached here too for the purpose of determining whether it constitutes a confidence of the Queen's Privy Council for Canada and whether it should be protected from disclosure under Section 39 of the Canada Evidence Act. I certify that under subsections 39 sub 1 and 2 of the Canada Evidence Act, the information referred to in the said schedule is a confidence of the Queen's Privy Council for Canada for the reasons set out in the schedule attached here too, and I object to disclosure of the information. Man, that's dense, isn't it? So a confidence means it's secret. We don't want it released. We say that this is secret information that cannot be disclosed to the public. Notwithstanding the fact that the government has promised, sunny ways and the most transparent government ever, this is too secret, determining how they decided that the AR-15 wasn't used for sport. Too secret, too far. All right, so I further certify that paragraph 39 sub 4 sub A of the Canada Evidence Act does not apply in respect of the information, as it has not been in existence for more than 20 years, and that paragraph 39 sub 4 sub B of the Act does not apply in respect to the information in question. If oral evidence were sought to be given on the content of the information, the disclosure of which I have in this certificate objected to, man, that's an ugly sentence. I would object to such evidence on the same grounds as described above in relation to the information in question. So basically, if they wanted to have me testify in person or somebody else testify in person about this information, I'd object to that too. All right, and then we've got the schedule, which basically says all of the documents that they were ordered to produce, they don't want to produce. Okay, so why do they go through and list all of this stuff? Well, I guess the next place to go to is to the actual section itself. So this is the Canada Evidence Act. And it notes confidences of the Queen's Privy Council for Canada. So this is a mechanism by which the government can say that they don't want to pony up information. So where a minister of the Crown or the clerk of the Privy Council objects, so objects is just they don't want to the disclosure of information before a court, person, or body with jurisdiction to compel the production of information by certifying in writing that the information constitutes a confidence of the Queen's Privy Council for Canada, disclosure of the information shall be refused without examination or hearing of the information by the court, person, or body. So what does this mean? Where they object in writing, and they say that it's a confidence of the Queen's Privy Council for Canada, that is enough for the disclosure to be refused by the court. So the court says, we're not, this is not to be disclosed. And in doing so, they're not allowed to look at that information. So this whole thing of the information going under seal is actually specifically ruled out by Section 39. And so definition, a confidence of the Queen's Privy Council for Canada includes, without restricting the generality. So this is examples, but it's not limited to these examples. It can include other things. So information contained in a memorandum, the purpose of which is to present proposals or recommendations to council. A discussion paper, the purpose of which is to present background explanations, analyses of problems or policy options to council for consideration by council in making decisions. An agendum of council or a record recording deliberations or decisions of council. Record used for reflecting communications or discussions between ministers of the Crown on matters relating to the making of government decisions or the formulation of government policy. A record, the purpose of which is to brief ministers of the Crown in relation to matters that are brought before or proposed to be brought before council that are the subject of communication or discussions, and draft legislation. So pretty much everything that they do, right? So definition of council, we can skip over that. Exceptions. So this is why you see them saying, hey, listen, these exceptions do not apply. So the first one they note that does not apply is a confidence of the Queen's Privy Council for Canada that has been in existence for more than 20 years. So mark your calendars, folks, because in 2041, we can probably get this information. And yeah, by that time, I'm sure you'll be real interested. Or a discussion paper referred to in paragraph 2B, if the decisions to which the discussion paper relates have been made public, or where the decisions have not been made public if 4 years have passed since the decisions were made. So discussion papers are less protected than other things. So Section 39 is a real wall to getting this information. Now, there is a case on all of this. This is sort of the leading case, and it is the case of Babcock and Canada, and it's a Supreme Court decision because this was fought up to the Supreme Court. So what the Supreme Court has said, essentially, is that this rule only applies as a rule of disclosure, because this was an issue that was raised in Babcock, because in Babcock, they'd actually already provided some documents, and then they said, whoa, 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 even though we already provided you those documents, now we want to invoke the cabinet confidence and say you can't use those documents that we already gave you. So the Supreme Court has said, no, this is a rule of disclosure, not of use. So if they've already disclosed it, then this doesn't apply. However, it does provide essentially that this is a very broad power, and that once that power is engaged, it has some pretty serious impacts. So let's have a look at some quotes here. So Section 39 permits the clerk to certify information as confidential. It does not restrain voluntary disclosure of confidential information. That's a key portion here, because what that means is that invoking Section 39 actually gives them very one-sided protection. They can say, listen, these documents are helpful to us, so we'll release those documents. But these other documents that are harmful to us, we're not going to release those. That's a bit of a problem, right? So this is made clear from the French enactment of Section 39, which states that Section 39 protection arises only dans le cas où, in the cases where the clerk or minister opposes disclosure of information. So when they don't oppose it, they can release it. Therefore, the clerk must answer two questions before certifying information. First, is it a cabinet confidence within the meaning of Section 39 sub 1 and 39 sub 2? And second, is it information which the government should protect, taking into account the competing interests in disclosure and retaining confidentiality? If, and only if, the clerk or minister answers these two questions positively and certifies the information, do the protections of 39 sub 1 come into play. More particularly, the provision that disclosure of the information shall be refused without examination or hearing of the information by the court, person, or body is only triggered when there is a valid certification. So, did they get the certification right is a key question here. And from my rough look at it, it looks like they probably did. It's not hard to manage getting the certificate right. So if the clerk or minister chooses to certify a confidence, it gains the protection of Section 39. Once certified, information gains greater protection than at common law. If Section 39 is engaged, the court, person, or body with jurisdiction hearing the matter must refuse disclosure. Disclosure of the information shall be refused. Moreover, this must be done without examination or hearing of the information by the court, person, or body. This absolute language goes beyond the common law approach of balancing the public interest in protecting confidentiality and disclosure on judicial review. Once information has been validly certified, the common law no longer applies to that information. So that's pretty heavy, right? Normally under the common law, if they're saying, hey, listen, this is secret information, then the judge would make that assessment, would look at the information and decide, should this be disclosed? What's the balancing of interests here? But once Section 39 is validly invoked, all of that stops. It's just a hard limit. So this raises the question of what constitutes valid certification. Two requirements are plain on the face of the legislation. First, it must be done by the clerk of the Privy Council or a minister of the Crown. Second, the information must fall within the categories described in Section 39 sub 2, both of which are real easy tests. A third requirement arises from the general principle applicable to all government acts, namely that the power exercised must flow from the statute and must be issued for the bona fide purpose of protecting cabinet confidences in the broader public interest. The function of the clerk under the Act is to protect cabinet confidences, and this alone. It is not to thwart public inquiry, nor is it to gain tactical advantage in litigation. Of course, how can the court determine if it's one of those things because they can't even look at the information? If it can be shown from the evidence or the circumstances that the power of certification was exercised for purposes outside those contemplated by Section 39, the certification may be set aside as an unauthorized exercise of executive power. So what does this mean? Well, this means that if you can show that the certification was used for improper purposes, thwarting public inquiry, or gaining tactical advantage in litigation, then you can theoretically strike this certification. Now, people might be saying, oh, that sounds great. Are they going to do that in this case? Probably not, because think about how difficult that's going to be to actually get that accomplished. In order to do that, you have to show those things without being able to look at the information. How is the court going to determine that this is a tactical advantage situation if they can't even see what's being prevented from, unless the clerk of the Privy Council comes forward and like confesses or something like that, you're unlikely to ever be able to get there. So a fourth requirement for valid certification flows from the fact that Section 39 applies to disclosure of the documents. Where a document has already been disclosed, Section 39 no longer applies. That doesn't apply here because they're still holding on to those documents. There's no longer a need to seek disclosure since disclosure has already occurred. Where Section 39 does not apply, there may be other bases upon which the government may seek protection against further disclosure at common law. However, that issue does not arise on this appeal, doesn't arise in the case we're dealing with either. So the court says in Supreme Court decision, similarly, the issue of inadvertent disclosure does not arise here because the Crown deliberately disclosed certain documents during the course of litigation. All right. Now, so that sort of provides us a little bit of background as to just how sweeping this power is. But one thing that's really come up is people have said, well, what else can you do? I mean, if they're not providing you with this information, isn't that kind of a big deal? Is there any other remedy that they can seek? And the press release identifies a big one. Let's talk about that. So we're here at paragraph 36, and this is again Babcock, the Supreme Court decision. This raises the concern that selective disclosure of documents or information may be used unfairly as a litigation tactic. The fear is that the Crown could choose to disclose only those documents which are favorable to its position and certify those documents which are detrimental. Yeah, I can't imagine the government ever doing that sort of thing. I mean, I can't say that's the case here, but it's certainly plausible. Selective disclosure designed to prevent getting at the truth would not be a proper exercise of the clerk's or minister's Section 39 powers. Moreover, the ordinary rules of litigation offer protection from abuse. First, government witnesses may be cross-examined on the information produced. Second, the refusal to disclose information may permit a court to draw an adverse inference. For example, in RJR MacDonald in Canada, the Attorney General's refusal to disclose information relating to an advertising ban on tobacco led to the inference that the results of the studies must undercut the government's claim that a less invasive ban would not have produced an equally salutary, so good, result. What does that mean? Well, it means that the court has the option of, and I say option, they're not required, but they do have the ability to draw what's called an adverse inference. Now, what does drawing an adverse inference mean? It means that the courts can essentially decide a fact, and that's a fact that is contrary to one party. Essentially, what the adverse inference here would be is, listen, you guys are hiding this information because it would hurt you, because you didn't do the things that the legislation required you to do in order to validly enact this ban. Now, it's up to the justice as to whether she wants to do that. That'll be an open decision. There's going to be, I can guarantee you, that's going to be a hotly contested issue. There's going to be major lawyer action on fighting over that question. But certainly it's open to the court to say, listen, if you guys did the job right, you'd be telling us and showing us that you did the job right. The fact that you feel that it's essential to hide this, that it's, embarrassing, or that you're thinking that this is secret, suggests that maybe you didn't do the job right. And they did that previously in the RJR MacDonald case, which was a tobacco advertising case. So there is potential here. I would like to see the court draw that adverse inference. I don't know if they will or won't. But hopefully that's provided a little bit of explanation into what has gone on at this step. We're not going to get that information. There is a possibility of challenging it, but as I've sort of mentioned, it's such a narrow and difficult road to get through that I can't see that being meaningfully argued, unless some new information drops in somebody's lap about this having been done wrongfully in some fashion. So really, the only thing left is to ask the court to say, listen, they're not giving us that information. If it was helpful to them, they would totally give us that information. So you should decide, without seeing the information, that it must have been real bad. And here's hoping that the court says it must have been real, real bad. But I can't say for certain. Anyway, as I said, lots of people wanted me to do this video. I feel it's a necessary video because this is a complicated and thorny topic. I hope I provided some clarity. I know this is a little bit of a longer one. It's not quite as long as some of my marathon epics, but it's still a longer video. So thank you if you've watched this far. Please like this video. Please share it with your friends. Please subscribe to see more content. I'm going to have links to all of the stuff I quoted in the description below. Check them out. I'm also going to have a link to my Patreon if you want to support me. I'd like to also thank my Patreon supporters at this time. At the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Farms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, Christopher Molina, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. I also want to thank all of you at the $10 level who will be in the crawl immediately following, as well as all of my Patreon supporters. But yeah, hopefully this has provided some clarification. If not, let me know what you're confused about in the question or in the comments below. I'll try to answer them. I may end up doing a follow-up video if it turns out I've been real confusing. And I'm sure somebody's going to ask, why isn't this a Scotch video? Well, here's the long and short of it. If I drank every time the government did something dumb or did something that annoys me, I would have a serious problem. So sometimes I just don't want to have a drink, notwithstanding the fact that that it might call for it. And yeah, I couldn't justify it here. Anyway, thank you for watching. I hope this has armed you with knowledge, and see you next time.